following program is made possible in part by the Dayton Bar Association.
Good evening. My name is Jeff Swillinger, and welcome to You and the Law. This is a monthly call-in show. Tonight's subject matter is DUI law. The program is brought to you by the Dayton Bar Association and Dayton Access TV, DATV. We have three guests tonight. Our first guest is Judge Fred Dressel of the Kettering Municipal Court. Our second guest is Betsy Deeds, Chief Prosecutor in the Fairborn Municipal Court. And our third guest is Charlie Roland, a DUI attorney with DUI law here in the greater Dayton area, and specifically I think Charlie's office is in Fairborn, and he'll tell you a little bit more when you have an opportunity to hear him. Again, we welcome your calls this evening. There will be a phone number that will appear on the screen. There will also, in the course of the evening, be a phone number for the Dayton Bar Association and the Dayton Bar Association Lawyer Referral Service. Again, we welcome you and hope that you will enjoy this third show of the 2018-2019 season. Again, my name is Jeff Swillinger. I'm an attorney in the Dayton area, and I'm your host and moderator. Well, let's start, first of all, by my now more personally introducing our guest. We have Judge Fred Dressel, again, of the Kettering Municipal Court. We have Chief Prosecutor Betsy Deeds of the Fairborn Municipal Court. And we have Charlie Roland, DUI law, a criminal defense attorney here in the greater Dayton area. I welcome all of you. Thank you for being here and helping us with this public service.
Thank you for having us. Thank you, Jeff.
Thank you. Now, Judge, you've been here before with my predecessor, Mike Monta, and Charlie, you have. Betsy, this is your maiden voyage with this group. Judge, let you start and tell us a little bit about you and a little bit about your thoughts on this topic tonight as we get started.
Thank you. Jeff, you and I have known each other for years. I came to Dayton right out of Ohio State Law School in 1982, served as a Montgomery County public defender for 6 years, was in private practice for 20-some years, and took the bench in Kettering in about 4.5 years ago in 2014. A lot of what I did in the public defender's office, also in private practice, involved OVIs on a fairly regular basis. And as a municipal court judge, it is a significant percentage of our caseload. So it's a topic that we deal with on a daily basis.
Okay. Betsy, why don't you go next?
Thank you. I'd just like to thank you again for having me here tonight for the invitation.
It's our pleasure.
Thank you.
Thank you for being here.
Thank you. I started my practice from the start at a prosecutor's office. So I started with the prosecutor's office in the city of Fairborn in January 2004, and I have been there ever since, 14 years. I am currently the only prosecutor there, so I handle every case that's filed there from start to finish, from filing through appeals. And a large portion of my caseload is OVI work. I do handle all the OVIs for all the law enforcement agencies that service that area, Fairborn, that area of Greene County.
Very good, thank you. And Charlie, as you give us a little background, I'm going to ask you to talk just briefly about OVI, DUI, DW.
Oh, yeah.
Okay. Since
yes,
we use those terms somewhat interchangeably,
right.
We'll try and be as correct as we can as the evening goes on.
Well, first of all, thank you for having me. Thank the Dayton Bar Association. This is a really nice thing that they do every year.
Well,
I've been in practice since 1995. For many of those years, I've been practicing exclusively DUI law, and it's changed. It's always known colloquially as DUI, but we have called it OMVI, we have called it DWI, we have called it many different things. all of it involves the act of driving when you have had too much, when you are impaired by a substance. So all of us here deal with that. We all have our different roles within the system. But I'm thankful that I get to do it. It's a rewarding practice, and I'm thankful to the judges and prosecutors that you work with. We are all in this together, and that's what we're hopefully going to say today.
Very good, very good. And you talked about a substance, I believe you said, and so as we go on this evening, we'll be talking about alcohol and what we in the general public might more traditionally say, and drugs, although alcohol is technically a drug, I believe. And you'll correct me if I misstate anything of that nature. But as the evening goes on, I'm sure some people will be very curious about the new medical marijuana laws and how they might impact upon OVI, DUI, OMVI law, which, why don't you touch on those definitions for a moment?
I'm going to refer to them exclusively tonight as just DUI. That's my term for it. An impairing substance can be anything, including marijuana, prescription drugs, alcohol. We see any number of people who are under the influence, which is essentially what we're trying to prevent. Anything that could cause you to operate a vehicle in an unsafe manner. And that's what the law, since I've been in practice, has become very, very pointed and very harsh over the years. We enforce them harshly. It is one of the main priorities of most law enforcement agencies. And as we go on with the implementation of the medical marijuana law, I think we're going to have a lot of people who are going to be surprised that they might very well be impaired by marijuana, even though they're using it legally and according to their prescription.
Okay. Now, and this is a good opportunity for us also to acknowledge that we are speaking to the law of Ohio here. And although it's my understanding that we have had callers in the past from as far away as maybe Denver, Colorado. First of all, this is the law of Ohio, and unless some exception is made in our conversation. You should also know that laws change. And the law as we address it this evening may not be the law months from now, a year from now, 2 or 3 years or even longer. So this is for your edification tonight and for the foreseeable future, but it's a good idea that if you have any problem or if you have any questions related to this topic tonight, that you check with someone. In this case, most likely it would be an attorney, to get the most accurate, up-to-date information. This is purely just advisory information. We're not here to represent anyone, just to give you general information to help guide you in your decision-making. So with that, Judge, I want to get back to asking you a little bit about the general topic tonight. Obviously, you've had experience as a lawyer and as a judge. Unfortunately, you see a lot of these cases, it's my understanding. Why don't I just let you take the floor here and give us some thoughts at this point.
Thank you, Jeff. Probably the thing that stands out about OVI law to me, I don't like to think of myself as old, although I'm rapidly approaching that, is that when I started in the practice, it was relatively simple. There weren't a lot of presumptions. There were no such thing as mandatory penalties, mandatory license suspensions, and over the years, the law has evolved to become much more strict, much less flexibility, and I think the important thing is that this is the result of many, many years of way too many tragedies from people driving under the influence, much as all of us, or at least you and I, Jeff, as children, our parents would be prosecuted for the way we traveled in cars. They didn't have mandatory seatbelt laws. They didn't have child restraint laws. And just like those have all evolved, so has the OVI law. We're in an age where there are per se violations. All that has to be proven is that, one, a person operated a motor vehicle, and two, that they had a certain concentration of alcohol or a substance of abuse in their system. And if that is proven in court, you lose. And the second thing that makes OVI law particularly harsh is that judges do not have a lot of discretion because of the mandatory nature of penalties, and they are progressive. On a first offense, there is a mandatory 3 days in jail. There is a caveat or an exception that a court may allow somebody to do a residential intervention program. The focus tends to be primarily on a first offender at trying to get to the root of a problem, aimed towards rehabilitation, education, assessment, and through one of these programs they do get assessed. We do determine, is this an isolated incident, or is this a person that's maybe already harmfully involved in alcohol, and maybe we can divert them into some counseling and try, the goal being to not have them come back. But as with anything else, if that doesn't work and there is a second offense or beyond, the penalties get progressively tougher. The judges have less and less discretion. And so I think that everybody sitting at the table would agree on the first offense. Generally, most courts, most prosecutors are somewhat oriented towards rehabilitation, and that changes quickly. If somebody's behavior doesn't modify, then the focus has to become protecting society.
Betsy, why don't you go next? If you have any comments on what the judge has said, then let that kind of lead into some general comments you might want to make about what you see in the course of your work.
Well, I would agree with the judge. I think that our overarching goal is really to keep people safe and really to keep people not coming back through our court. And my role as a prosecutor, I work with law enforcement for those first-time offenders to try and get them the treatment that they may need so we don't see them coming back through again and again, but also to hold those people accountable who maybe didn't get the message the first time through, unfortunately. Because our goal is to keep people safe and to keep people to really think hard about whether or not they're going to get in a vehicle if they have ingested some substance that may impair their ability to drive. I don't see a lot of, I think we were speaking earlier in the green room, that a lot of people that come through the first time, that's enough. But we do see those repeat offenders and the penalties do get much more harsh, as the judge indicated. And that's unfortunately where we're heading at this time.
Okay, so you see the legislature who makes the laws creating new penalties.
That's correct.
And possibly, I would suspect, even before we get to the penalty, addressing potentially what constitutes a DUI in terms of the level of intoxication. When I was a young lawyer, people would say it was 0.10. And what did that mean? Well, it depended on whether you had a test, what type of test it was, whether it would involve taking your breath or your blood or your urine. And so it wasn't quite 1.0 uniformly. That would be for another night to explain. But today, although I think Charlie can speak to the different types of tests much better than I could, the test is lower now, the threshold for being impaired and potentially being guilty. So, Betsy, I'll move on unless you had any further comment at this point.
Well, I think there's a distinction to be made there too. There's the prohibited level, and then there's impairment. Those are, the law makes a distinction there. So someone may test under the prohibited level, but still may be impaired, depending on their experience drinking or what substance they've ingested. So I think that needs to be an important distinction that we make. It's not all about the 0.08 and above. We may have someone who's an inexperienced drinker that may test under but still be impaired and still pose a danger on the roadway. So we need to think about those things as well when people are considering whether or not they should get into a vehicle and drive.
Okay, very good. Very important, and I'm glad you made that point. Charlie, why don't you talk a little about, again, overview of your thoughts for the evening, and maybe go back to this point about the law of the impairment, the difference, and what that means when you're speaking to a client who comes into you.
Well, in my years of doing this, I've been in practice since 1995, it's been a real sea change. We used to have DUI be a punchline. You would see, I always refer to Otis the drunk from Mayberry, the town drunk, who was always the punchline. That's not how we view it anymore. It's viewed very differently, it's viewed very harshly. And I deal with policies, which are made by the legislature, the procedures which the police officers use, and then you deal with the person. And that's where I feel like we can make the biggest change, because there are people who are rounded up under these new policies and procedures that do deserve a defense. And I see my role not as doing anything other than making sure that everything works the way it's supposed. If I do my job well, I'm going to make the police officer better, I'm going to make the job easier for the prosecutor, and I'm going to make the policy better for the judge to implement. So there are a lot of things that I think that we all agree on, and we all have our different roles. And the penalties do keep getting harsher. And the penalties, but more pervasive than that, is the way that we all view this as a society. And it's been a sea change, and nobody wants to see anybody out there driving drunk, and there are ways to prevent it. And what we always tell our clients, don't call me, have a plan. Always have a plan when you're going to go out and drink.
Okay. Too often you don't get a call until afterwards, right?
Right. You see people who haven't, they think they can't leave their car where it's at, or they just want to get home, or they may not be aware of how many they've had or what level they're at, and it is often a bad idea to take that chance. So
I used to tell my children, who are adults, that I don't care where you are, and I don't care whether you are afraid to spend the money. You get a taxi. This was more so before Uber, when they were younger, or Lyft, or any of the services. I said, just call me, and I'll be there to give you a ride. If you have to call one of the services, that's fine. I'll pay for it. You don't have any money. It's always the right way to go. Don't worry about where the car is. The car can stay where it is.
and the good thing is we're now in a position where we have those advantages that we did not have before.
Yeah,
we
exactly.
have Uber and Lyft and all these different things, but before you even pursue that idea, don't put yourself in a dangerous spot. It sounds so simple. I'd love to defend you, and I hope that I'm good at what I do, but at the same time, if you have a plan, you can avoid all this, and that's the best possible outcome.
Just before we go forward, this being the season, and there have been articles in the newspapers recently, as yesterday in the Dayton Daily News, lead articles about this subject matter. Let's talk about services that are available and made available to the general public for people who might find themselves in a position where they've had too much to drink. They're at a bar, they're at a restaurant. There are services, actually free or reduced fee services, rather than using a cab or Uber or Lyft, are there not?
Yes, Matt Heck, through the Montgomery County Prosecutor's Office often offers free rides within the greater Dayton metro area. I know a lot of businesses are hopping on this idea where they get a bus or something to transport people back and forth to a Christmas party. It's just we see a general level of responsibility when it comes to drinking. So yes, there are ways to avoid it, and always have a plan.
And those services, how can people become aware of the services, for instance, of the prosecutor's office? Is that on a website of the prosecutor's office? Can they access it through local television, radio? Do you know?
I
do
don't
any of
know.
you
I know that we post it.
I usually see it in the news.
You, you post it on your website?
I post on my website, and we also have Dayton DUI on Facebook, where we post checkpoint updates, and we post free rides, and we post all of the different things that will keep people informed about what they can do to avoid DUI, and if they need to contact an attorney.
So this is a good time. Why don't you tell people how they could access your website to read about this and learn this?
I'm Dayton DUI on Facebook. I'm Dayton DUI on Twitter. and I'm at DaytonDUI.com. And we try to reach out and make sure that everybody has access to good information and make sure they don't find themselves in a bad situation.
Okay. Do the courts, and I'm not trying to create any obligations here, but do the courts do any of this type of thing, Betsy? Are you familiar with providing the public any of these, not in terms of providing lifts home, but in terms of information? If somebody says, well, gee, I didn't know who to contact or how to get that information, is there anything posted through the Fairborn Municipal Court or any of the other courts with which you're aware?
There's nothing posted through Fairborn Municipal Court. I'm not aware of any other court that would post a service for a ride home.
Just information about the services. There's Judge?
I think we don't have that in Kettering either, but I think that the message that we really want to impart, and I think Mr. Roland already said this, is have a plan. There are, and it's encouraging to me, I know a lot of young people in their 20s, that's the demographic my 3 children are in. Uber's a way of life for them. True designated drivers are a way of life, and there's a big difference. I've heard more than once the excuse, well, I was the most sober of the group, that's why I was driving. Well, that's not a designated driver, but if you go out, many bars, many restaurants will serve free drinks, non-alcoholic drinks, to a designated driver. The most expensive cab ride or the most expensive Uber fare is a fraction of the economic impact of an OVI, and it's money well spent. So.
And Judge, you brought up the economic impact, but as we were talking in the green room earlier, the impact of a DUI can be so far-reaching. This is all part of your plan when you're thinking about how you're going to spend your evening and what the impact of spending it unwisely would be. You see this when cases come to your court. The economic impact of being incarcerated, maybe losing a job, losing the source of income for one's family or a source of income, cost of defending a case, appeals, all sorts of things. But what about the human costs in addition?
Well, in the lucky case, and I would say in a municipal court, most of the OVIs we deal with, if there is an accident in a valve, it's usually a non-injury or definitely non-fatal. When you get to the level where you're unfortunate enough that the human cost involves serious injury or death to a person, then you're talking about common police court, felony charges, and prison in all likelihood. But it's many people, if you're a professional and you have licensure or you are a sales rep for a company that drives a company car, or you're a over-the-road truck driver with a CDL, a DUI can be the kiss of death. You become uninsurable. So many of the people that come through and do get rehabilitated, and several do, after one, but they still have long-term effect of higher insurance premiums. They've had legal fees. They've had fines, and it's a significant cost. I've seen it estimated up to $10,000, the overall impact. I'm pulling that number out of a hat. I've seen that, and I'm sure that can vary from market to market and defendant to defendant, but it is significant.
Yeah, and that's really just from my perspective, just a short-term economic cost. It doesn't even address some of the other points you made about costs if there's a serious accident, or people lose their job and their source of income and all those types of things. Well, let's suppose someone is getting ready to go out. So let's take an example here. This holiday season, and they're either planning to go out with friends or family to a neighborhood bar, or going to go to a restaurant and have dinner. We've talked about having a plan and having some idea of if you're going to drink, what might be the consequences of that, and think about, are you going to have a designated driver or one of the folks in the group not going to be drinking at all. But let's suppose somebody does become impaired and they are driving. Now, Used to be, they could, I think this is still the law, even for the aging former DUI lawyers like me, that one would have seen cases, my point being one would see cases where somebody might be weaving, they might, their vehicle might be crossing different lines out of their lanes, they might stop at a light, they might run into the back of someone. We call those things with probable cause for the police stopping you, right? Okay.
I'm always going to argue probable cause.
Okay.
I just want to make
Okay.
that argument.
And is there a reason for the stop? But what happens? Maybe Betsy, we could talk about this from the law enforcement perspective a little bit, because I've had clients in many years past, in all different scenarios, where the police found reason to stop them. And they were things that at the time were not even as obvious as weaving in one's lane or outside of one's lane, or going the wrong way on a one-way street, but something, oh, your license plate light was out, you had failed to re-register your car timely, and they happened to notice that your registration had expired, or some other reason to stop the vehicle. What might happen if you're stopped for this, or at a checkpoint? Why don't we talk about checkpoints for a minute? I know, Charlie, you want to talk about that later too, but you're stopped at a checkpoint that are set up during the holiday, what might happen?
In terms of?
Well, in terms of what you might expect if you've been drinking and you're stopped for one of these reasons, and the police say, please stay in your car, I imagine. May I see your driver's license?
Certainly there's going to be personal contact with the officer once the traffic stop is made. The officer will approach the vehicle, will introduce him or herself, usually explain the reason for the stop, but at the same time the officer is also evaluating the driver, seeing if there are any, if there's any smell, if there's any slurred speech, if there's any containers of alcohol that he or she can see. Certainly the officer's all the time assessing the situation. It may just be a stop for a simple, tail light or something that may not be immediately indicative of someone who's under the influence. But then once the officer approaches the vehicle, starts seeing some of those other indicators that might lead him or her to believe that this person may have been drinking, then the officer is going to take a much more in-depth look to determine whether he or she needs to investigate that further. Probably going to ask license and insurance, may start asking divided attention questions, may start asking that person to do one or two things at a time to see if the person can follow directions, to see if the person can follow along with the conversation. Probably will want to get the person talking, and may lead to asking that person to exit the vehicle to then maybe perform standardized field sobriety tests, and then take it from there depending on how that goes. But certainly if the officer does not, and I think that may be a misconception, there does not have to be the weaving or the crash for an OVI arrest to be made. If there is what may on its face be an innocuous reason for a stop, but then the officer makes contact with the person and then develops those indicators that lead him or her to believe the person's under the influence, then it may result in an OVI arrest at that point.
Okay. Charlie, you want to pick up with that at this point, or I don't know that necessarily leads to the first call, but what might happen then if somebody is advised that they're under arrest for OVI?
I think it was an excellent analysis. That's what we do. We look at, there are three phases to an OVI arrest. The first is the driving. Is it bad driving, or is it something innocuous? We all have cell phones, and unfortunately some of us look at our cell phones and it may cause us to weave. Certainly not a cause of impairment. In Kettering, however, that looking at your phone is distracted driving. So we have an ordinance, yeah. So depending on the jurisdiction. But there may be innocuous reasons for that.
And just before you go any further, Betsy touched on a number of things that could lead to ancillary charges too.
Yes.
The officer's going to be looking to see whether or not your registration has expired, whether your license is expired, whether you have insurance. You may be fortunate enough not to be cited for DUI, but any of these other things might lead to a citation and potentially even arrest, as long as I recall.
And there are a lot of things that can mimic impairment. Not everyone speaks eloquently at times. You have a toothache, you may sound like you're slurring your words. You have hay fever, you may have bloodshot or glassy eyes. it's the job of your attorney to explain, the job of your defense attorney to explain why what the officer is seeing as signs of impairment may not be impairment. And it is not illegal to drink and drive. You can have a glass of wine, you can have a glass of beer, and then get in your car and drive as long as you're not impaired. And we have to make sure that the arrests for impairment, which are life-altering and can really impact the course of someone's marriage, life, parenting, everything, we have to make sure that we're not arresting people who are not impaired. And I think that as the laws get harsher and harsher, the job becomes more and more important to make sure that we're arresting the right people and we're making society safe.
Judge, you want to enter the picture at this point? I see a role for you very quickly coming if an individual is taken into custody and a court appearance is on the way, but I want to comment at this point on anything that's been said because I have a couple of questions.
Well, a couple things. One, the first time I see somebody on an OVI, often they don't have an attorney yet. They may have been arrested in the wee hours and not made bond yet, and they're going for the judge for the first time, or they may be coming in after having bonded out, just a few hours before or a day or two before. So the first encounter I have, I'm going to advise them of all their rights under Criminal Rule 5, their right to have a trial, their right to have jury trial, because this is a case that does carry incarceration if you're convicted, your right to be represented by counsel, and you would be surprised at the number of people who, well, I just want to get this over with. And I won't allow that. I think I have a duty to protect people from themselves sometimes. But assuming that we're now to the phase where we've continued it, they've retained counsel, both Betsy as a prosecutor, Charlie as a defense lawyer, they're going to have evaluated the case for those very things that we were just talking about, cues or indicia of being impaired. And like with anything else, not every officer is as highly trained as the next guy. Not everyone does everything by the book. They're both going to evaluate the case based on the law as they understand it. Were proper procedures followed? Were these tests administered in conformance with standards? If they're not, or if there is a questionable reason for the stop, Charlie's going to look into that. Oftentimes there will be a pretrial conference followed by maybe a motion hearing as to whether is there an issue that is dispositive of the case. Can this not go forward because the test won't be admitted because somebody didn't follow a proper procedure? And oftentimes those hearings cut both ways. Sometimes a reluctant defendant who's not quite sure they want to follow their attorney's advice or don't believe their attorney's advice as to the strength of the case, through a hearing will have an opportunity to hear evidence that they didn't realize was quite so overwhelming. And then if I could just touch on one other thing that it makes DUI law a lot easier than it used to be from the trial aspect is virtually every police agency now has these incidents on video. And there's oftentimes, both audio and video of the entire encounter between the police and the citizen. And oftentimes there's a sizable amount of the driving even before the stop. So if you have the person who was all over the road versus the person whose license plate light was out, we know that going in, and I think it helps both the prosecution and the defense, evaluate their case much more quickly, and it also makes them give probably better advice. Both Betsy, do we want to take this to trial? And Charlie, do we want to take this to trial? Or is there a possible resolution?
Thank you. Thank you. Comments? What the judges?
Videotape cuts both ways often. I know Betsy and I look at them the same way, and oftentimes we're able to conclude that we agree on a lot more than we disagree on after watching the tape.
I agree with that.
Okay. Now, for the folks who are listening to this, sometimes I remember clients would hear things and they would hang their hat on something in particular. If a law enforcement agency has video cameras, on them. Is that is available to the defense, of course, but is it required that they have that on them at all times? And if they don't, how does that impact upon potentially the arrest and then the prosecution of the case?
They're not required to. I have some agencies that just have cruiser video and some that have cruiser and body cam.
Okay.
And the body cam is particularly helpful because obviously we can see what's happening when the officer goes up to lean into the car to talk to the person. We can see exactly what's happening at that point. They're not required to have it. Where we run into problems is where there's a malfunction or there's something that gets deleted later. Those become issues that Charlie and I will litigate in court. But there is no requirement, and if simply something isn't functioning, that may make our job a little bit more difficult in determining what we want to do with the case and see if there's a resolution that we can come to. Because if there's a video that we can watch, and we've been doing this a long time and know what we're looking at, it's a lot easier to come to a resolution when everybody can look at the same thing. When there's not a video, it becomes a little bit more difficult sometimes to resolve the case. But in terms of a legal analysis, there's nothing that is necessarily a detriment if there's not an automatic detriment if there is no video, I guess is what I'm saying.
Okay.
It just makes the case a little bit more difficult to handle practically.
Okay. But the availability of it, and for some reason, the functionality is, as you described, or dysfunctionality may exist in a given case, or the failure to use it is just one factor that a judge or a jury might consider down the line in evaluating the evidence, I gather. Okay. Okay. Let me ask a question about the individual has gone through what you refer to as field sobriety tests. I think as young defense lawyer, we used to try and emphasize the word exercises rather than rather than tests, excuse me, so they didn't rise to the level of tests and what consequences that might have in people's minds. I don't know if you go through that today, but they've gone through some exercises, and the officer moves forward, and the officer says, ask some questions and the individual is willing to answer those questions on the spot, so to speak. At what point might the issue then become one of taking a breathalyzer test or intoxilyzer, whatever the proper term is, or urine test or blood test? Why don't we talk about that a little bit? Or Charlie, you want to speak to that issue? What point does that arise? And I'd ask any and all of you to comment upon the consequences of taking or not taking the test, not only in terms of the DUI conviction, but or as well as one's license and one's license suspension or potential suspension.
I think the answer, you used to see, I think attorneys would put billboards up that would say, don't blow, don't take the test. You don't see that now because we've criminalized refusal in certain circumstances. If you are a juvenile, if you have a commercial driver's license, or if you have a prior offense, an attorney can't tell you not to blow. An attorney would be telling you to commit a crime if he told you not to blow under those circumstances.
If you're a juvenile,
if you're a juvenile,
if you have
a commercial driver's license,
a CDL.
Yes, a CDL or a prior offense. There are dire ramifications for refusing to take the test.
Now, a prior offense meaning a conviction for DUI?
Yes.
Okay, does it have to be a conviction in Ohio?
It does not, but there are certain outs. There are off-ramps that are available if it's not in Ohio.
But if the prior conviction was for a reduction from a DUI to a lesser charge, does that mean the same thing? If you still have reckless operation as a lesser included offense, if the prior conviction is reckless operation, would that same admonition apply?
It may not, because the person would have, it would depend on whether or not an administrative license suspension, the automatic license suspension that's given when you get either test over or refuse to take the test. If an ALS were to attach, the admonition would be the same for the attorney not to tell you not to blow.
Okay. Okay. Does the officer in those circumstances, ask the questions if it may be obvious once they know their age, whether they're a juvenile, but the other two may be less obvious to the individual or to the officer until he or she runs a check. But
Be careful with the distinction that the person always has the choice not to blow. They would just have to deal with the ramifications.
You tell us.
Well, listen, I'm at heart nothing more or less than a civil libertarian. You should have the right to not give evidence against yourself. And that part of me knows that taking that test is giving evidence against yourself. But I do follow the rules very carefully and say that there are times where I can't say don't give that evidence. There are other times when the best possible option would be to take the test and give everyone the proof that you are not impaired at that level. The attorney is not in the position to tell you how much you've had to drink. You're going to know that information. And whether or not you give that evidence against yourself is your choice, ultimately. But there are times when an attorney can't tell you not to blow, and there are times when you have to make that decision on your own. That's why we don't have billboards anymore with people out there saying, you know, don't blow under these circumstances.
But you've gotten those calls where somebody is on site,
Yes.
and they say, what should I do, right?
Yes. And I tell them that you know what you've had to drink. You know whether or not you are in a position where you are impaired, and you know the ramifications, because I go over the ramifications with them. And then I tell them that it's your choice to decide whether or not you blow, unless, and then I do my off-ramps, which is juvenile CDL, or you have a prior offense.
I actually had a client who I did not represent. This is more recent times. And I had not been doing that work for years, but actually called me from the back seat of a police cruiser on his cell phone, and somehow he was able to make a call even though he was cuffed. And he had his phone, and he's calling to see whether he should take the test or not. Go into the details of that, but that was an unusual set of circumstances. I don't think it's usually that way. But, okay. But there are a lot of ramifications of taking the test or not, and you've both touched on that. A refusal can result in a license suspension, and under some circumstances, what happens may even result in additional charges, such as what you just described, right?
Yes.
Okay, so carrying the scenario through, let's suppose he or she is stopped and they are advised that, well, I don't know what the proper terminology would be. Why don't you tell me what happens next when the officer believes they have probable cause? How do they advise the individual about taking a test?
That's been memorialized in a certain form that the officer, once he or she makes the arrest, must read certain advice to the arrested individual verbatim off a certain form. And as Charlie mentioned, CDL drivers, there's certain information that they read to everyone, and then if that person has a CDL, there's additional information that they have to read for that CDL driver that explains to them what the penalties are for refusing, what the penalties might be if they take the breath test and test over in terms of a license suspension. And then they give the individual the opportunity to either take or refuse either the breath or urine or blood test.
Is that usually done at the site of the stop or once they've been incarcerated?
It's officer's discretion whether he can read that. And the form is the two entities that are now involved in your life. You have the police officer who's invoking the criminal justice system, and you have the administrative license suspension with the officers using to bring the Ohio Bureau of Motor Vehicles into it. And we all know that when they become involved, it becomes a lot more complicated. So there are two now entities that have control over you and your license, and to a large extent your life at that point.
Okay. Now, again, at times here, we've started to go down the road of getting into the weeds a little, which I think is very important, and I didn't want to stop you, but just in the interest of time, let's move this forward. Let's say that the individual is advised that they're now being arrested for driving under the influence. They're cuffed, they're taken into custody. This is not a situation where the individual's been involved in an accident, where they might go to the hospital and possibly have a blood test, rather than taking the test, either what we call it the intoxilyzer machine, is that correct?
Yeah.
Yeah, the breathalyzer was way before that. Am I right that it's rare even to take the blood test or urine test? Urine might be invoked when the officer feels that there might be reason to consider the person's been taking drugs of a different nature than alcohol. And so they want to test to see whether there's a presence of drugs. Is that right?
That's correct.
Okay. So they're taken into custody. They're taken down to the station. They're subject to both the DUI laws as well as the administrative suspension. Then we get back to the province of this gentleman sitting to my right here very quickly. They may seek to try and get bonded out during the night, if it's during the night, or even during the day, I suppose. But let's suppose they're not bonded out and advised to come back to court, but they remain in custody and they go to court. Judge, what happens at that point? And if you want to add something
Are we
else.
talking, are we still on the refusal issue, or are we moving beyond that?
Well, let's move on from that, because we have 10 minutes, and I think that there are a few points when we get down to about 5 minutes that I just want to talk about the interlock system and maybe a couple nuances in the law that are either here or coming.
Well,
We're taking some broad
I am
jumps.
the, I guess the arbiter of if there is a case and there's a hearing as to whether something comes into evidence or not, or whether somebody ultimately is found guilty or not, if it's tried to me instead of a jury. But most of what I do is really dictated by the outcome of the case, as far as I don't have a lot of discretion. I have certain mandatory minimums that I have to apply, as we talked earlier, and I think that applies both in terms of the actual offense itself and some of the issues you were just discussing with refusal. As you get progressively down the line from first offense to second offense to third offense, I have less and less discretion. I always have the ability to impose up to 6 months in jail on a first or second offense, up to 1 year on a third offense. I must impose the 3 days we talked about in either jail or intervention on a first offense. I must impose 10 days on a second offense, and I must impose 30 days on a third offense. There's another thing that I think we should talk about just briefly, and I know we don't have a lot of time, but there are 2 tiers of tests in OVI. And if you test over 0.08, we talked about a per se violation, that you prove the test, you prove the operation of the vehicle. But there's what we call a super DUI level. If you test at 0.17 or above, the mandatory minimum penalties that we just went over double if you're convicted of driving under the influence at a level of 0.17 or above breath or blood. So as I think I alluded to before, and I think most judges that I know, and in my experience as a judge in private practice, the first offense, rarely do you see really heavy sentences. We try to stay within the law. We do what we must do, but it's focused upon help, rehabilitation. But as somebody reoffends, I think sometimes there's an assumption that minimum penalties are always appropriate, and sometimes they're not. So I guess I have to evaluate each case based upon its individual circumstances and a person's overall record, not just as far as alcohol-related offenses, but their overall respect for law and their criminal history. Sometimes people that have substance abuse problems driving also have many other issues that have brought them into the criminal justice system.
So we're at the stage then that those types of factors come into play once the individual is in court, and depending upon what we lawyers call motion practice, motions to suppress, to potentially have certain evidence thrown out on the basis that it was not properly obtained, or evidence to be kept in evidence because the finding of the court is that it was properly obtained. And if the case then goes forward, then there can either be a trial on these offenses to a judge or to a jury. And there can be multiple charges made and depending upon what brought about probable cause and what else the officer finds when he or she stops an individual, there could be charges for which the penalties may be, in some measure, driving without a license. It still carries 6-month license suspension, or driving with a suspended license.
Depending
six-
on again, that law has
Yeah.
changed significantly
Okay.
depending on the number of prior convictions, the type of suspensions,
So,
the number of suspensions. But yes, theoretically, you could have a situation where there are companion charges that have equally, potentially long sentences.
And I think I said suspension there. I meant driving while you're licensed under suspension could be a sentence of maybe a minimum of 6 months, or a maximum of 6 months, or it could be more. Is that right? Is that what you're saying?
Well, I'm saying that the penalties for driving under suspension depends on the type of suspension, the prior history of the person. Can be anywhere from no jail at all, just fines,
Right.
up to 6 months, depending on
I
the
see.
circumstances of that individual.
Okay, very good. We have a little less than 5 minutes left here, and I wanted just to touch upon a few subjects that I refer to as maybe new or nuanced subjects, such as individuals driving, if they've been convicted, the interlock system, if that's the proper terminology. Would like to speak to that, Betsy?
We, in my court, we don't utilize that. So I don't have any experience with the use of that particular instrument.
Judge, do you want to talk about that, or
Just
same in your-
briefly, again, given like everything else with the OVI law, the flexibility I have to give somebody driving privileges during their period of suspension depends on a lot of factors. If you have a second offense or more, before I can lawfully allow you to drive for any reason for privileges, you have to serve some period of what they call hard time with no privileges, and that's going to vary according to the circumstances. But even once you've served that, I must impose a requirement that you get an interlock system. And quite simply, an interlock system is you blow into a machine. If it detects a certain level of alcohol, then your vehicle will not start. It will not be functional. And that is a requirement that courts must impose on second offenses or more, and may impose even on a first offense.
Who pays for that?
Usually the defendant, unless there's an indigent alcohol fund that might in certain circumstances.
So another cost, going back to what we talked about originally.
And that's
Betsy, you were going to
very
add something to
expensive.
that?
Just a little correction from what I said. Our court does utilize the interlock for that purpose, but not for the unlimited privileges purpose, and that was my misunderstanding of your initial question.
Okay, well, it's probably my question, your misunderstanding. Charlie, you want to comment on anything that's just said, or?
I've seen great reluctance for judges throughout. I'm lucky enough to travel throughout the state. A lot of judges are having difficulty implementing the new law, which was recently done, called Annie's Law, and they are referring back to the old system, which requires hard time and then allows people to get their privileges after the court has more control over it. So I know we can't get into that to a great degree, but judges are using the old system, and interlock is used for second and third offenses.
You mentioned Annie's Law. I know we talked in the green room briefly about that, and that probably could stand some extensive conversation on that. Do you want to just briefly summarize what that?
I think summarizing Annie's Law is it gives us a 10-year look back. It used to be that the enhanceable offenses would occur within the last 6 years. Annie's Law has expanded that to 10. Mm-hmm. It gives judges some discretion to utilize the interlock device more, and it extends the driving privilege, the driving suspension from 6 months to 1 year mandatory in all OVI convictions for first offenses. That's a thumbnail sketch.
Okay, I understand. Okay, we're down to about a minute and a half here, so let me ask you, Betsy, if you'd like to add anything. Is there a subject that maybe we could touch upon very briefly that people should be mindful of, or just a closing remark?
I would just reiterate the overarching theme of have a plan, so you don't have to deal with any of this material. Just have a plan before you go out and enjoy your holidays, and hopefully that you won't see me or Judge Dressel.
Okay. Charlie?
The great thing about this is that we're all in this together. We've all got to watch out for each other. No one wants you to get involved in a DUI crash. No one wants you to be impaired. And if you do, the criminal justice system will be there, but look out for yourself and everyone else first.
Okay. And Your Honor, please.
I would just reiterate that to have a plan, and please do not be a slow learner. We have an excellent defense bar in our community. Charlie and many other lawyers do a fine job of representing clients, but they are lawyers bound by the law. They are not magicians. They can't change really bad facts. They can't undo really bad decisions. So with that in mind, anybody can make a mistake once, but having done that, learn from it and don't be back.
Okay. Thank you. Thank you. Thank you for being with us this evening. You can check the website for DATV, and this program will be on YouTube later this week. Thank you very much. We'll see you next month. Good night.